High Court imposed a cost of 5 lakh rupees on litigant who repeatedly abused the process of court by filing successive pleas and suppressed crucial fact. The plea was filed challenging the resumption order of a land which was allotted to the petitioner subject to certain conditions. The court found that the petitioner did not fulfill the conditions and filed successive petitions, suppressing facts and pleading ignorance. A bench of Justice Arun Puri and Justice Vikram Agrawal said, the case of the petitioner is based upon falsehood. Clearly there was is a conscious and calculated suppression of crucial facts, as also the orders passed by this court. The successive petitions filed and withdrawn by the petitioner revealed that he was circumventive, artful and insidious, and, indeed, abused the judicial process to the hilt. Often, particularly of late, the judicial process, time, resources and infrastructure are abused by unscrupulous and litigious. The court raised concern over litigants waiting for their turn while court's time is wasted. At the cost of a litigant, pursuing a genuine cause, who quietly wait for his/her turn to mature, with unflinching faith and trust, even though the previous generation perished, while pursuing the cause, said the court. These observations were made while challenging a resumption order issued by Haryana government for non-compliance of conditions. After examining the submissions, the court noted that the land was allotted to the petitioner subject to certain conditions wherein he was required to start construction of a building within a period of 1 year, as per the approved building plans, from the issuance of letter of allotment/offer of possession. Even after 4 years the petitioner had not even submitted the building plans, leave alone constructing the site, and start production, per the terms of allotment, it added. Resultantly, in 2005 he was served with a show cause notice, under Section 17(3) of the Haryana Urban Development Authority Act, 1977, for resumption and forfeiture. After the resumption proceedings had already been initiated and a show cause notice dated the 1st of August 2005 was issued, the court noted that petitioner hurried to submit the building plans on the 12th of August 2005. And also managed to obtain the actual/physical possession of the site on the 14th of September 2005. The bench further highlighted that the resumption order was challenged before the appellate authority. In its order, the appellate authority found that the petitioner proceeded the construction on the resumed site and the estate officer failed to safeguard its property. However, it stated now that the site had been fully constructed, the order of resumption was set aside. Accordingly, the site was restored, subject, however, to certain conditions, including that petitioner would pay the extension fee and other dues, and start production within 6 months, failing which, the order of resumption would come into force automatically. The petty owner again failed to comply with the conditions and the order was challenged in revisional authority. The revisional authority said that the construction was done by a GPA holder, in connivance with the officials, illegally carried out the entire construction. The original allottee was nowhere in the picture. Though the subject site was allotted to set up a specific industry, but it was constructed for residential purposes. But still, being cognizant that resumption is the last resort, and before passing the formal orders, on the 19th of April 2011, directed the estate officer, Panipat, to ascertain if any industrial unit was actually being run at site. The officer found that no plants or machineries were installed in the premises either. The building was lying closed permanently. Consequently, the revisional authority set aside the order passed by the appellate authority. Further, the chief administrator, was directed to hold an inquiry as to how the building plans were sanctioned, resumed site was allowed to be constructed. The authority also opined that delinquent officers should be punished. The petitioner did not challenge the revisional authority order but chose to file pleas questioning the resumption order. The division bench noted that the petitioner filed successive 5 petitions before the High Court and suppressed crucial facts. Speaking for the bench, Justice Arun Puri said that power of resumption is to be used only as the last resort. However, in conspectus of the factual position obtaining in this case, quite clearly resumption was the only and the inevitable option. For abusing judicial process, time, resources and infrastructure, the court dismissed the plea with a cost of 5 lakh rupees. Title: Naveen Kumar Batravi, State of Haryana and others. Click here to read/download the order. The